Please be seated. Oh, got a crowd on the screen there. Could one of you identify yourself as Mr. Nielsen?
I'm Mr. Nielsen, Commissioner.
Thank you, Mr. Nielsen. And could the other two people on the screen please identify themselves?
Certainly. Commissioner, my name is Rubenstein and I'm counsel acting for Mr. Nielsen.
Thank you.
And Mr. Grant with me, who is solicitor acting for Mr. Nielsen.
Thank you very much. Now, before you commence to give your evidence, Mr. Nielsen, you'll have to take an oath or an affirmation. Which do you choose to take?
The oath, please.
Right. And do you have a Bible there?
My counsel has provided a Bible.
Thank you. Now, I have your name here as Michael Nielsen. Do you have another forename or not?
My middle name is James.
James?
Yes.
Thank you. So taking the Bible in your right hand, please repeat the oath after me. I, Michael James Nielsen.
I, Michael James Nielsen.
Swear by Almighty God.
Swear by Almighty God.
That the evidence I shall give to this commission.
That the evidence I shall give to this commission.
Shall be the truth, the whole truth, and nothing but the truth.
Shall be the truth, the whole truth, and nothing but the truth.
Thank you, Mr. Nielsen. You may now put the Bible down. And Mr. Rubenstein will ask you, we'll examine you to commence. Thank you, Mr. Rubenstein.
Thank you, Commissioner. Mr. Nielsen, you're here today in answer to a summons from the Perth Casino Royal Commission dated the 9th of September 2021. Is that correct? That's right. And the Commission has provided you with a list of topics to be included in a witness statement to be adopted by you. Is that correct? That's correct. And have you prepared a witness statement covering those topics? Yes. You have a copy of the witness statement with you? I do. And the Commission has put a barcode on the witness statement. I'll show you the copy with the barcode. It's WIT.0014.001.001. Can you see that? Yes, I can see that. Now, can you turn to the last page on your witness statement? On my witness statement or on the one with the barcode? I think on your witness statement. Yes. Is that your signature on that page? It is. And how many pages are in that witness statement? 15. And have you read that witness statement recently? I have. Are there any corrections to that witness statement? There was one very small correction. What was that? It was a typo in paragraph 76. The penultimate sentence, which appears on my witness statement at the top of page 14. The penultimate sentence should read, I don't recall whether they were provided to the WA gaming regulator. The word to is missing. Yes, and Mr. Nielsen, with that correction, is the contents of your witness statement true and correct to the best of your knowledge and belief? It is. Commissioner, I attend to that witness statement.
Thank you. The amended witness statement bearing that identifier will be an exhibit in the Commission. That completes your examination, Mr. Rubenstein?
It does, Commissioner.
Thank you. Yes, Ms. Verity Longdroppett. Oh, sorry, Ms. Longdroppett.
Thank you, Commissioner.
More than one name confuses me.
Mr. Nielsen, my name is Ms. Longdroppett. I'm one of the counsel assisting the Commission. You've given a witness statement under summons in respect of some topics, and you've also given evidence in the Bergen inquiry last year. Is that correct?
That's correct.
And you'd have a copy of your witness statement with you?
The witness statement for this Royal Commission.
For this Royal Commission, yes, Mr. Nielsen. I may take you to some paragraphs at certain times, including this first question, which relates to paragraph 5 of your witness statement, where you identify some of the roles that you held within the Crown Group during your time in their employment. At subparagraph C, you say that you were General Counsel and Company Secretary of Crown Resorts Limited from late 2007 to November 2017, correct?
That's correct.
And in your role of as General Counsel of Crown Resorts, did you report to Mr. Craigie as CEO?
That's correct.
And in respect of your role as General Counsel of Crown Resorts, you would agree that you had a high level of responsibility to protect the Crown Group, including each of the respective properties from legal risk.
Yes, I think I would agree with that.
And in your role as Company Secretary of Crown Resorts, you were accountable to the Crown Resorts Limited Board?
Yes.
And you commenced this role as Joint General Counsel Group Company Secretary in 2007. And am I right in saying this was precipitated by the Publishing and Broadcasting Limited demerger in December 2007?
That's correct.
And in your role as Group Secretary, you were also the Secretary of a number of wholly owned subsidiaries of Crown Resorts Limited?
Yes, that's right.
And in relation to the Perth Casino, you were Company Secretary of Burswood Limited from December 2007 to 2017, is that correct?
Yes, right.
And what did this role entail?
Well, I was one of two company secretaries, and my role was more the head office company secretary, if you like. I looked after the ASIC filings and ASX filings with assistance from my team. I assisted with the distribution of board papers, with record keeping, maintaining the company register, and occasionally assisting with particular agenda items for the board.
In respect of your role in relation to board papers, was it your usual practice to read the board papers of Burswood Limited before you distributed them to directors?
Not that I can remember, no.
Okay. And so in respect of that role, how were you able to satisfy yourself that the Burswood Limited board was adequately informed of relevant material?
My co-company secretary would have assisted with the preparation of the papers and the collation of the papers. Me and my team really provided a centralised distribution process and record keeping process.
So in your view, Mr. Preston was responsible at that time for reading the board papers to ensure that Burswood Limited was properly informed of particular matters.
That depends on what time you're talking about. The other secretary of Burswood changed over time. For most of my time, I think it was actually Mr. McGregor.
So depending on who might have been secretary at whatever time, it was the joint company secretary's role, not yours, to ensure that the board papers reflected the information that Burswood Limited board needed to be made aware of at the relevant time.
Yes.
And you were the company secretary of Burswood Nominees Limited from December 2007 to 2017?
Yes, I think that's right.
And did this role mirror your role in respect of Burswood Limited?
My memory is that Burswood Nominees didn't meet as a separate board very often. It wasn't Burswood Limited was the active board that governed the Crown Perth entities, if you like. But Burswood Nominees only kind of passed official resolutions and didn't really meet as a board in a true operational sense.
And is that also your understanding in respect of Burswood Resort Management Limited?
Yes.
And so in respect of these two entities, can you describe what your role was as company secretary?
Again, it would have been record keeping, maintaining the register, filing the necessary documents with ASIC. When official decisions of those companies did need to be made, then either minutes or resolutions would have been prepared for the directors to either have a brief meeting or to sign by way of a circular.
And in your roles as company secretary of the three Burswood entities, do you agree that you were responsible to the respective boards?
Yes.
Can I take you to paragraph 29 of your statement, please? And you here have identified 8 different committees of the Crown Resorts Board.
Yes.
And so, as I understand it, these are committees of the Crown Resorts Board. What especially makes them committees of the board as opposed to another type of committee?
Well, they receive delegated authority from the board to deal with certain matters, and they comprise board members. The committee members are board members.
Right, and there was also, during your time as General Counsel and Joint Company Secretary, a VIP committee, is that correct?
No, I don't. There wasn't a committee by that name. Certainly not a committee of the board.
Yes, I understand that it wasn't a committee of the board. I'll come to that in a second. But there was a committee that convened that discussed matters to do with the International Commission business.
Well, there was a group of people who I think did that, but I wouldn't have called it a committee.
And that group of people did not have delegated authority from the CRL board to consider those matters?
No, not that I can remember.
And so what was the genesis of this group of people?
Sorry, Councillor, I'm just struggling to remember the genesis of the group. It was a desire, I think, by management to more closely monitor and understand the VIP business and deal with issues that came out of the VIP business.
And when you say management, do you mean management at the respective properties?
I think it was the group, the Crown Resorts CEO, CFO. I think the chair was involved in the decision to have that group meet on a regular basis.
And who is?
I am struggling to remember. I'm sorry, it was a long time ago. I'm just struggling to remember how it came about, that committee in the first place. Well, not committee, that group in the first place.
Right. And when you say the chair, who are you referring to?
Okay.
And so if it's not a committee, would you describe these meetings as informal?
I didn't attend the meetings, so I would, I think, but I didn't attend the meetings.
But you did on occasion attend the meetings, didn't you, Mr. Nielsen?
No, I don't recall attending those meetings.
And in respect of those meetings, were the discussions minuted?
I don't know. I didn't attend, so I'm not sure.
But if they were to have been minuted, it would have been your role as the company secretary of the Crown Resorts Board at the time?
Not well, that's hypothetical because I didn't attend, but That's it, not necessarily, no.
Right. I just want to test your attendance. I'm just going to jump forward in my notes. If we could get up CRL.579.019.5104, please. This may take a little bit of time as I'm jumping ahead. So this is an email sent by Roland Tyler on the 4th of January 2017.
Yes.
Do you see that? And the title of the subject line of the email is VIP meeting documents.
Yes.
And the recipients of this email are Rowan Craigie, who I understand to be the CEO at this time. Is that correct? Mike Johnston. Could you enlighten the Commission as to who Mike Johnston is, please?
Mike Johnson was a Crown Resorts Director and he was the Finance Director of CPH.
Right. You're a recipient of this email?
Yes.
Do you see that?
Yes, I do.
Ms. Tagoni?
Yes.
Mr. Felsted?
Yes.
And Ms. Maguire?
Yes.
Correct?
Yes.
Right. And this email says, attached to profiles for the following customers to be discussed at today's conference call. You see that?
Yes.
And there are two junket profiles which have been updated since the previous meeting. Do you see that?
Yes.
So this indicates that, at least in respect of consideration of these profiles, there had been at least another meeting prior to this one to consider them. Do you agree with that?
Yes.
And then junket new profiles. One of them is Chow Chiok-wah of the now infamous Sun City. Do you see that, Mr. Nielsen?
Yes.
And Quinn Said-Shin.
I can see all of that, yes.
Right. And so I might come back to this a little bit later, but I do have a couple of queries in relation to what you've just told me about these VIP meetings. This would indicate to me that you were, at least in respect of this particular meeting, in attendance.
This is a different meeting. This is not the one I thought you were talking about. This is something completely different.
Right. How is it different? Can you explain to the Commission what's different about it?
Sure. So after Crown had a number of employees detained in China in October 2016, Crown implemented a process of monitoring very closely what VIP activity was taking place in the circumstances of having those people in detention. So this only occurred for a period immediately following the arrests in October of 2016.
Right. And in respect of the period prior to October 2016,
Yes.
the matters of approval of junkets and so on were considered at the VIP committee meeting.
I don't think that's right. I'm not aware of that. Not this committee anyway. This group of people was formed specifically to closely monitor the VIP business in the light of having people in detention in China who we were trying to have released.
Right, thank you. And operator, can you please take this down? In respect of the group of people that you were talking about earlier in the examination,
Yes.
the group that included the Crown Resorts CEO, the CFO, and the chair, the group of people that formed the informal group that considered VIP matters.
Council, I didn't say that those people were on the committee. You asked me the genesis of how that committee was formed. And I tried to remember who was involved in the decision to form that group.
Right.
But
So,
they weren't on that group that I can remember.
right. And can you tell the Commission who was on that group?
I will struggle to remember all the people. The people who I can remember who were on that group would have been Mr. Felstead, Mr. Johnson, and I think Mr. O'Connor. But there were probably others that I can't remember.
Right. And that group of people, to the best of your knowledge, did not report to the CRL board?
No.
And so and in respect of the VIP meetings that started to occur after October 2016, did those discussions get reported to the CRL board?
I don't think so. The fact that there was a process was known to the board, but I don't think the detail of what happened at the meetings was reported to the board.
Right.
To the best of my recollection.
And so in respect of matters to do with VIP and any relevant risk that was attended to that issue or to that area, how was the CRL board able to properly consider that risk?
Sorry, your question's unclear to me, Councillor. I'm
Sure.
not sure what it was.
In circumstances where the group of people that were considering matters to do with the VIP business were not reporting to the CRL board, how was the CRL board able to consider the risk that attended to that area?
I object to that question. That's asking this witness to comment on the state of mind of other people, which is something that he cannot do.
I don't think it is. I think it's asking him to say how, as a matter of practice, that risk was brought to the attention of the CRL board, if at all.
If that's the question, then I withdraw my objection. But if it was a question that asked for this comment on the view of the board, I maintain the objection.
Well, Mr. Nielsen, consider the question in light of my interpretation of it.
Yes. So the VIP business was managed by management. CEO and a group of people who managed the VIP business, and the head of the VIP business was Mr. Felstead. Mr. Felstead came to Crown Resorts board meetings, and there was a section in the regular, what was called CEO report in Crown Resorts board meeting papers that would deal with the VIP business. That committee or group that we were talking about before was not, to my understanding, a decision-making group or a group that managed the business. It was a group that looked at issues that came out of VIP and looked at ways of enhancing the VIP business. It wasn't managing the VIP business, to my recollection.
Right. And so in respect of any risks that might have been considered by that group, it was incumbent upon Mr. Felstead to alert the CRL board of those risks in his CEO report.
That would have been one way he could alert the board to risks, but there was also a risk management process that both Crown Melbourne and Crown Perth had, where risks were identified, analysed, recorded and then monitored, and that was reported up through the Risk Management Committee of Crown Resorts, So there was another mechanism whereby risk could be reported.
Right. I might come back to that later. In respect of paragraph 31 of your statement, you explain your roles and responsibilities by reference to the CRL board charter. If we could get the board charter up, please, it's crl.622.001.0039. And if we could scroll through to the duties of the secretary, please. Having a technical issue. Keep going, please, operator. Thank you. At clause 4, the role of the company secretary. My question is, I know that not all of the companies...
Is it possible for thank you.
Sorry. Thank you. My question is this. I know that not all of the companies of which you were a secretary had a charter or were subject to the ASX guiding principles as private companies, but in your view, did you perform the same roles in respect of each of those companies as is outlined here?
No, I wouldn't say it was the same, no.
In what ways did it differ?
I would have a role in some of those issues, but not necessarily all.
And in respect of the balance of those issues, it would be undertaken by your co-company secretary, whoever that was at the time.
Yes.
In paragraph 33 of your statement, you say that part of your role was to advise on board governance and issues associated with the management and running of the board, and that your focus was to ensure that the board was properly and adequately informed and to facilitate the smooth running of the board. I want to ask you about keeping the board adequately and properly informed.
Yes.
In your view, how did you achieve that?
By working with CEO, CFO, Head of Development at Crown Resorts to ensure we had an agenda that covered the necessary items and that papers were prepared to inform the board in respect of those items.
And I note earlier in respect of Burswood Limited, it wasn't your usual practice to read the board papers, but in respect of the CRL board, was it your practice to read the board papers that were provided to that board?
I would read most of them, yes.
And you've said that in respect of drafting the agenda, you consulted with the CEO and the CFO. Would you always consult with them first before drafting the agenda for the CRL board?
I might have a go at a first draft and then circulate it for comments.
And you sought their input from a managerial perspective?
I'm sorry, I don't understand it.
Sorry, I can rephrase it.
They were managers, so yes, I suppose it was a managerial perspective. Although Mr. Craigie was a board member as well.
Okay, thank you. You've been asked in your summons topics various questions about risk management, and we've diverged into that area already this morning. We may come back to VIP later. But I do want to gain a better understanding of how risks were managed when you were General Counsel and Group Secretary, particularly in the context of the centralisation of functions at group level. If you could please turn to page 12 of your statement.
Yes.
I understand the effect of your evidence at paragraph 68 to be that, as at the time of the Publish and Broadcasting Limited demerger in late 2007, the properties being Crown Melbourne and Crown Perth had their own dedicated internal risk management teams. Is that correct?
That's my recollection, yes.
And the effect of your evidence is at 69 is that in late 2007, when Crown Resorts became the parent company, that the process at properties level should be replicated at group level. But unlike at properties level, the parent company did not have a dedicated risk manager, so that responsibility fell to your team and ultimately your role as general counsel. Is that correct?
Yes, that's right.
So in effect, you would have considered yourself the risk manager for Crown Resorts.
I never thought of myself that way. Certainly my team, which I was responsible for, was responsible for ensuring that process was run smooth.
Do you recall in 2008, after the demerger, that CRL adopted a risk management policy?
I don't recall that, although I've seen some documents that supplied me overnight, but I identified the document, but I didn't separately remember that.
Right, if we could please get that up. Thank you, operator. And this is the risk management policy that was in force in 2008. Do you recall, Mr. Nielsen, that this risk management policy was in force for the entire time that you were General Counsel of Crown Resorts Limited?
I don't have a specific recollection of that, Councillor, I'm sorry.
But in your role as Company Secretary and General Counsel, you would have been aware of this document at the time.
I assume so, but I don't have a memory of it now.
Thank you. Operator, if we could please go to clause 1. And I just want to read to you the first paragraph of that clause. It says, while the Crown Board assumes ultimate responsibility for the risk management of Crown, it has delegated the oversight responsibility for risk management and internal control of major risks of the company to the Crown Risk Management Committee. Here, when it refers to ultimate responsibility for the risk management of Crown, did you understand at the time that meant the CRL board was responsible for the oversight and control of risks of each of its wholly owned subsidiaries?
As I said, Councillor, I don't have a memory of this particular document or how it came into being or was drafted. I mean, I can try and interpret the words now, but that's all it is an interpretation of the words now.
During your time as General Counsel of CRL, was it your understanding that Crown Resorts, the parent company, was responsible for oversight and control of the risks of its wholly owned subsidiaries?
I think Crown Resorts certainly had oversight of risk over the whole groups, which included its main operational subsidiaries, but it was conscious of there being what we thought was quite a robust risk management process at those major subsidiaries quite independently, and that had been carried on for a time before the Crown Resorts entity was formed.
Right, but was it your understanding that the ultimate responsibility lay with the parent company?
Yeah, I think that's right, Councillor.
Thank you. Do you recall during... Thanks, operator, you can take that down. Oh, well, thank you. Do you recall that it was an overall strategy of Crown Resorts Limited after late 2007 to centralise management functions at group level?
I'm not sure that that's right. In late 2007, that evolved over time.
And from when do you consider that most management functions were centralised at group level?
I think that process was still ongoing even as I left the group in 2017.
And do you recall, though, that it was a strategy of Crown Resorts to centralise management functions at group level while you were General Counsel?
I don't recall it being a strategy. I wouldn't have described it that way.
How would you describe it?
It was just an evolution of the way the company was managed, how the group was managed.
And part of that is in relation, part of the manifestation of that is the 8 CRL committees with delegated authority, correct?
No, I don't think that's to do with the centralisation of functions.
Okay. If we could go to pub.0013.0001.0825, please. And you'll recognise this as the Crown Resorts Limited Annual Report of 2014.
I do.
And as Company Secretary, were you involved in the drafting of this report?
Parts of it, yes.
And as General Counsel, were you in General Counsel or Company Secretary, were you involved on the ultimate authorisation of this report going out to the market?
Ultimately, the board authorised that to go out to the market. But I was involved in the process to a degree, yes.
Thank you. If you could go to page 35, please, which is 0859. I think it might be 39. No, 0859, 2 pages back, please. Thank you. And you'll see at Principle 1, functions reserved for the board.
Sorry, Councillor, it's very hard for us to read here.
Sure, I'll try to get the operator to bring it closer.
That's better.
Thank you. And if you scroll down, operator, just so I can see the full paragraph, please. Yeah, thanks. You'll see that under functions reserved for the board, it says the board is responsible for guiding and monitoring Crown on behalf of its shareholders. In addition, the board, in conjunction with management, is responsible for identifying areas of significant business risk and ensuring arrangements are in place. Sorry, it just moved. Ensuring arrangements are in place to adequately manage those risks.
Yes, I can see that.
And the business risk that's referred to here are the business risks that accrue at the properties, correct?
I would interpret that as being across the whole business.
Including, though, the risks that accrue at Crown Perth and Crown Melbourne.
That would be part of it, yes.
And do you agree with this, that Principle 1, the way that it's phrased, projects to the market that the CRL board is responsible for the risk of the group of companies?
Yes, I think that's right.
Thank you. If you go to page 0.0866, please, operator. And Sorry, one page before. (0865). Thank you. Principle 7. And it says, if you could, thank you. Crown has established policies for the oversight and management of material business risks and has adopted a formal risk management policy.
Yes, I can see that.
And it says at the final paragraph, the policy sets out procedures which are designed to identify, assess, monitor and manage risk at each of Crown's controlled businesses and requires that the results of those procedures are reported to the Crown Board, correct?
Yes.
And so do you agree then that as at June 2014, the management of risk was a centralised function of Crown Resorts Limited?
There was a centralised function for risk management, which, yes, there was a centralised function for risk management at Crown Resorts.
I just want to place the role of the management of risk into context by reference to the Risk Management Committee Charter. Now, you referred to the Risk Management Committee earlier in the examination. The Risk Management Committee had delegated authority from the CRL board to deal with issues of risk. Is that correct?
I think that's right, yes.
And ultimately, you would agree that it was the Risk Management Committee's job to assist the board with the task of managing risk in the group of companies.
Yes.
I wonder if you are familiar with this document, which is the Charter, the Risk Management Committee Charter.
Again, I don't have an independent recollection of it, but I have seen the documents that the Commission supplied overnight and had a quick look at.
And you were on the Risk Management Committee during your time?
No, I wasn't a committee member.
But you attended committee meetings?
Yes, that's right.
And you provided papers to the committee?
Yes, well, papers were provided to the committee and my team was responsible for the collation and distribution of those papers, but my team also contributed to the content of those papers.
And you, including you personally?
Yes.
Yes. If we could please go to the duties at clause 3. I'll just give you a moment to read those duties.
Yes, I've read those.
Can you please explain to the Commission how the Risk Management Committee was able to discharge those duties?
Well, it's as set out in my witness statement. The committee received a report twice yearly, to the best of my memory, which resulted from a series of processes starting at individual property level and their risk management committees, and in some cases where we had separate joint ventures or investments arising out of those businesses, being reported to a centralised, if I can call it that, group of managers, including both Crown Resorts and Crown Perth and Crown Melbourne executives who would, if you like, stitch the whole thing together and produce the matrix that ultimately went to the report to the risk management committee, which I identified risks, identified controls and mitigation factors, which assessed consequence likelihood ratings, and ultimately provided a risk rating. And those were reviewed twice yearly, to my memory, and reported to the board, to the committee, rather, the risk management committee.
Right. And this is the process that you describe at paragraph 71 of your statement, is that correct?
I'm just reading that paragraph.
Certainly, Mr. Nielsen.
Yes, that's right.
And so the process that you describe in 71 is your team, your council team, being predominantly you and Ms. Manos, were responsible for the production of, you refer to it as a table or matrix. I'm going to refer to it as a risk register. Is that correct?
Well, there was a risk register, and there was also a report against the higher level risks.
Yes.
So I would call the risk register the entire risk register, and the table or matrix would be the report of the high level risks and developments in respect of those risks.
Right. And so from what the risk register outlines all risks, low and high, and the report against material risk would delve deeper into into what your team, or in consultation with others, deemed to be the highest risks for the company.
Well, it wasn't for my team to deem what the rating of the risk was. That was a function of a group who would come together and debate and form a view, and we would be part of that, but we certainly didn't get any final decision on the matter.
Right, and the group you're referring to is the Risk Management Committee.
No, the group I'm referring to is the group I'm referring to in paragraph 71, which would involve Crown Resorts executives, but also Crown Melbourne and Crown Perth risk managers, and generally their risk managers, who would input the feedback from their internal processes and their thinking behind their risk ratings at property level.
Right, and so that group would meet prior to the Risk Management Committee convening to have that discussion and to hash out those risks?
Yes, that's right.
And then as a result of that discussion, the risk register would be updated?
Yes.
And risk ratings would be given to particular items or particular risks?
Well, generally they already had ratings, so they might be adjusted if people thought they were more or less risky, or if there'd been another control identified over the risk or something like that. So it would be updated, it wouldn't be redone every time.
Right, and was it at this meeting that it would be decided if any new risks would be added to the risk register?
So remembering there was a process of Crown Melbourne and Crown Perth beforehand, where their internal risk management committees would have met and looked at their risk profile, and they would have considered the question of potential new risks. So they would have brought any new risks on their register to us, and we would have then looked at those risks as well as any risks we might have identified as new risks.
Right, and then the final decision would rest as to whether or not a new risk was added to the register, would rest with this group that would meet prior to the RMC meeting.
If there was a new risk, yes. Any update to that risk register, that group would decide upon, correct.
Right. And then the risk register was given to the RMC as part of its committee papers,
Yes.
along with the report against material high risk.
Yes, that's right.
Thank you. And you said you weren't a committee member you weren't a member of the risk management committee, but you're in attendance at those meetings,
That's right.
and you took the minutes of those meetings.
Either I did or Mr. Manos did. I can't remember now which of us. We divided up the committees a bit on who took the minutes.
And insofar as any of the risks were discussed, sorry, I withdraw that, I'll rephrase it. And at the risk management meeting, there would then be discussion as to each of the risks identified in the risk register, or only some?
I'm struggling a little to remember the details of the discussion at the meeting. I'm sorry. There was certainly discussion of some risks. I don't believe they went through every risk.
And to the extent that risks were discussed, that would have been minuted.
If it was a material discussion, it should have been minuted.
If we could please go back to the Risk Management Committee charter, please, operator. And if we can go to clause 3.2. And it says the committee will assess the adequacy and effectiveness of internal control systems for the mitigation of significant business risks.
Yes, see that?
And approve and review internal control compliance processes for compliance with relevant laws and regulatory requirements.
Yes.
The assessment described in 3.2 subparagraph A, the assessment of the adequacy of internal control systems. That assessment, in your view, occurred during the discussion of the risk register at the RMC meetings?
Yes, that's right. There were controls were part of that, of the paperwork that was provided.
And any assessment of whether or not there were adequate internal control compliance processes for relevant laws and regulatory requirements, that was also undertaken during discussion at the Risk Management Committee.
Yes, in the context of that report that we've talked about earlier.
Thank you. If we could please go back to your statement at paragraph 75. You say that the minutes of the Risk Management Committee meetings were provided to the Crown Resorts Board at the next meeting. And the Crown Resorts Limited Board wasn't provided with the risk registers or the report against material high risk, were they?
I'm not sure about that, Council. I don't remember whether they were provided with that on occasions or not.
But it was not your usual practice to provide the CRL board with risk registers or the report against material high risk, was it?
Again, I'm not sure about that. I'm sorry.
Right. But ordinarily, the way that the CRL board would be informed about the consideration of risk would be through the provision of minutes of the RMC, correct?
I certainly remember that. They certainly got minutes, and Mr. Dixon was invited to speak to the minutes.
So they definitely got the minutes, and you're not sure if they got the risk registers.
I'm not sure about that, whether they got that on occasions.
And you're not sure as to whether or not they were provided as a matter of course the report against material high risks.
I don't think as a matter of course they were provided, but they may have been provided at some time.
Perhaps in an exceptional situation.
Maybe. Again, I have a very hazy recollection. It was quite some time ago.
Right. And so perhaps then you won't agree with me when I say the CRL board would rely on the content of the minutes of the RMC meetings to discharge its responsibility as to risk.
I would have said that was I think that's probably right. That would be the primary thing they relied on.
And perhaps, again, this is a matter about which you don't have a memory, but would you agree that it was the usual practice of the CRL board to simply note the minutes of the RMC?
I just don't, there were so many meetings, I don't remember what happened at all of them. I'm sorry.
Thank you, Mr. Nielsen. You've talked about the risk management processes at each of the properties, that they had their own risk management processes.
That's my understanding, yes.
I just want to go through the risk management process at Crown Perth level. Crown Perth had its own risk management committee, correct?
I believe so. I don't know that it was called that, but they had a committee that I think conducted that function.
Yes, lowercase risk management committee. I think it was called the Executive Risk and Compliance Committee. Does that ring any bells, Mr. Nielsen?
That does ring a bell, yes.
Thank you. And this was the committee of Crown Perth which provided risk and compliance oversight of the Perth casino operations?
I think so, yes. I didn't participate on that committee, but I did see some papers from it.
Right, but you were aware of its existence?
Yes.
And you were aware that this was the committee that... Sorry, I withdraw that. And as far as you're aware, did this committee keep its own risk register for the operations of Crown Perth?
That's my understanding, yes.
And this was the risk register that was fed into the meeting that occurred with that group of people prior to the RMC meeting?
Yeah, that's my understanding, yes.
And is your understanding that the ERCC reported to the board of Burswood Limited?
Again, that's my understanding, yes.
And the way in which it did that was primarily through a document entitled the Legal Risk Compliance Report?
I'm not sure about that, I'm sorry.
In the course of collating the board papers to the Burswood Limited board, do you recall seeing a legal risk and compliance report?
I don't have a specific memory of that, I'm sorry.
What did you understand the purpose of the to be the purpose of the ERCC updating the Burswood Limited board?
Oh, it was to in a similar way that the Crown Resorts internal risk management group, if I can call them that, reported to the risk management committee. It was a way for the Crown Perth management to report to the Crown Perth board on their risks, their identification of risks, their controls and mitigating circumstances, their rating of risk, any new risks, any risks that had ceased to be relevant. A similar sort of process to the Crown Resorts process we've been talking about earlier.
And so it was incumbent upon the Burswood Limited board to consider the updates?
Incumbent on. I'm sure the board considered the updates. It would be the paper is put before a board, it should consider the paper, yes.
And the Burswood Limited Board was expected to assess its accuracy?
When you say expected by who?
Well, but expected by, was it its duty to assess the accuracy of the ERCC, or was that a duty that fell to the CRL board?
I'm not sure I would describe either board as having a duty to assess the accuracy of it.
Okay. Do you consider that it was that the Burswood Limited Board should have appropriately challenged management at Crown Perth in respect of the contents of the updates?
I think it's a board's duty to assess the information in front of it, and yes, to test it, to seek clarification of it if necessary. So that's all part of a board function.
And if in the course of that assessment, if they had any concerns about ERCC risk and compliance oversight, what was Burswood Limited's role in respect of those concerns?
Their board supervised their management, and their board, they wanted management to do something or to change something or to take an action, they were able to tell them to do so.
Including to give direction to the ERCC?
Yes, to the managers that comprise that committee, yes.
Right, and I'm just wondering how that fits in with the centralisation of the function of risk management at CRL level. Can you explain that tension to the Commission, please?
It's the same risk profile that went via that report to the Burswood Limited Board would be fed up into the Crown Resorts risk profile and assessed by the Crown Resorts Board. The Crown Resorts Risk Management Committee, sorry.
Right. And so both Burswood Limited and the Crown Resorts Risk Management Committee had a role to play in the oversight of risk at Crown Perth.
Yes, I think that's a fair statement.
And am I right in thinking then that there's no real clear demarcation of responsibilities in respect of risk management between the Burswood Limited Board, or there wasn't, sorry, I'll rephrase that. There wasn't during your time at CRL, at Crown Resorts, a clear demarcation of responsibilities between the risk management that was the responsibility of Burswood Limited and that was the responsibility of the RMC in respect of Crown Perth.
That's probably right. There's probably an overlap of responsibility and an overlap of oversight.
As to paragraph 77 of your statement, you're describing another review in addition to the ones that we've been speaking about this morning. Is that correct?
Yes, that's right.
And can you explain what that review entailed?
Yes, well, it's as it's set out in my statement that Mr. Craigie asked Mr. Barton and I, in advance of Crown Perth board meetings, I think that was the timing, to sit with the Crown Perth CFO, Crown Perth General Counsel, Crown Perth Risk Manager, Crown Perth Internal Auditor, and go through those papers. I'm sorry, I forgot the name of the body again, but the one we talked about earlier, with them and ask questions and probe and act a little bit like a risk management committee, if you like.
Thank you. And what was the upshot of these reviews? Who did you report to?
I might say that those reports covered more than just risk, that those set of papers covered a whole lot of other things other than just risk. So there was internal audit, litigation reports and other things. But if any items, any material items of concern or of action came out of those reviews, I would report those to Mr. Craig.
And in respect of audit, did you have any contact with Rachel Murray, the internal audit manager at Crown Perth?
Occasionally, yeah, and she would attend those meetings. She was in attendance at those meetings.
As part of the review process that you've described in paragraph 77?
Yes, that's right.
And did you have any other contact with her aside from these meetings?
I don't remember. I may have, but I don't specifically remember. I'm sorry.
That's okay. Thank you. And you may not remember this either, but the internal audit managers at Crown Perth were involved in the creation of 3 major documents. Do you recall that?
No, sorry.
I'm just going to test if this rings any bell, the strategic audit plan.
I don't remember that, I'm sorry.
That's okay. And the internal annual audit report.
I don't remember that either. I'm sorry.
And the quarterly audit report.
I don't remember that. They may have been things that I knew about, but I don't now. I'm sorry.
Thank you, Mr. Nielsen. Commissioner, I'm about to launch into a lengthy new topic. Perhaps this would be a convenient time.
Yes. Mr. Nielsen, we will now take morning tea. I know it's a bit past your morning tea time, but we'll give you 15 minutes maybe to have some lunch. We will resume again at 25 minutes past 11 our time, which is 25 past 1 your time, I understand.
Thank you.
All right, we will now adjourn.
All rise.
be seated. Yes, Ms Longdrop.
Thank you, Commissioner. Mr Nielsen, just one more question on the topic of risk management structure and structure in general. Do you know why the Board of Burswood Limited did not have any committees?
No, I can't. I don't know. I'm sorry.
Thank you. In your statement, you say that as company secretary, you are a company secretary of a number of wholly owned, non-operational subsidiaries within Crown Resorts Limited.
That's right.
And one of those subsidiaries was Riverbank Investments Proprietary Limited.
Yes.
And the purpose of that company was to own and operate a bank account.
That's my recollection. One or more bank accounts. Yes, that's my recollection.
And that account has been the subject of investigation in the Bergen inquiry.
I think I'm not across everything in the Bergen inquiry, but I think that's right.
And do you recall that in 2013, Riverbank Investments had an account with HSBC?
I'm not sure about that. I'm sorry.
And do you recall that Riverbank Investments account with HSBC was closed in 2013?
I don't remember that. I'm sorry.
And do you remember that Riverbank Investments Proprietary Limited then subsequently opened an account with ANZ?
No, I don't remember that sequence of events. I'm sorry.
Right, but you're aware that at one time during your time as a company secretary of Riverbank Investments that it held an account with ANZ?
Yes, I think, yes. I mean, I'm hesitating because I've seen documents that the Commission sent me overnight. I'm trying to think what I knew before I saw those documents. And I think I knew they had an ANZ account. I knew that because it was before Bergen, you're right.
Thank you, Mr Nielsen. And you might recall that in early 2014, ANZ raised concerns about transactions in the Riverbank account.
Well, again, I had documents put to me at Bergen, and you've sent me some documents as well. And I do have a recollection of a meeting with ANZ, but more broadly than that, my meeting is hazy.
Right. Perhaps I can take you to some correspondence relating to the ANZ closure of the Riverbank account, which might jog your memory. Could we please bring up CRW.529.008.8581? And this is an email from you dated 3 March 2014 to Deborah Tagoni and Scott Howe. And you say, I will give you a call about this. Do you see that?
I just see that. It's very small on our screen.
Right. And underneath,
Yes, I can see that now.
right, and underneath you have also sent an email to Joshua Preston, CCing in Craig Spence,
Yes.
on Monday 3 March 2014 saying, Josh, can you please give me a call about this ASAP, as I think we will need your help in dealing with it.
Yes.
And Craig may be able to give you some background to the problem.
Yes.
And can you just explain to the Commission who Craig Spence is, please?
My memory was he was the CFO at Crown Perth at that time.
Right. And operator, if you could scroll down, because you are forwarding an email to these parties and the email is on the second page of this document. If you can go up to the start, please, the start of this document, please, operator. Sorry, if you could zoom, no, sorry, second page, if you could zoom out. Right, thank you. And you'll see the email chain begins with an email from Paul Birch of ANZ to Mr. Ken Barton on the 28th of February 2014, correct?
Yes.
and it says, Ken, find a proposed agenda for the discussion on the bank accounts, etc. Correct?
Yes.
And then on the 1st of March 2014, Ken Barton emails you and Mr. Costin saying, looking at this agenda, we may need more time to prepare. Correct?
I can see that, yes.
And Ken Barton was the CFO of Crown Resorts.
Yes, that's right.
Right. And this email is attended with 3 attachments, which will also put this line of correspondence into context. The first is the agenda that's referred to by Mr. Paul Birch. If we could please bring that up, operator. It's CRW.529.008.8538. Sorry, 83. 8583 are the last 4 digits. Do you recall seeing this agenda, Mr. Nielsen?
Only as part of the documents that you and Bergen have sent me.
You said
So
that,
I should say the Bergen inquiry.
thank you. You said your evidence is that you have an independent recollection of a meeting that occurred with ANZ. Do you consider this to be the agenda for that meeting?
I don't remember it being the agenda of that meeting. It looks to be a document that was intended to be an agenda for a meeting with ANZ. I don't know whether it was the actual agenda.
Do you recall how many meetings you attended with ANZ during your time as General Counsel of Crown Resorts?
No, but I didn't attend many meetings with ANZ.
Right. And this would be as an attachment to the email from Mr. Birch to Mr. Barton, the agenda that Mr. Birch was referring to in his email to Mr. Barton. Do you accept that?
That's what it appears to be.
Thank you. And another attachment to the source email is CRW.529.008.8585. Could we bring that up, please? This is an email chain as well, starting on the 27th of February 2014, from Mr. Birch to Mr. Barton. Do you see that?
I can see that email. Yeah. Do you want me to read it, Councillor?
Yes, please, Mr. Nielsen.
Yes, I've read that now.
And operator, if we could just bring up CRW.5, sorry, I'll bring that back one step. In that email from Paul Birch to Mr. Barton, he says, thanks for your time yesterday. As discussed, I have attached a letter on the Riverbank Investments account closure. Operator, if we could go to CRW.529, before we go, it's subject to a non-publication order, so if we could not put it up on the screen. Thank you. CRW.529.008.8586. And this is the letter that, do you agree that this is the letter that Mr. Birch is referring to in his email to Mr. Barton in respect of the closure of the Riverbank Investments account?
It appears to be, Councillor.
If we could go back, operator, please, to CRW.529.008.8585. At the top of this email chain, Mr. Barton is emailing you, attaching that letter, to say we will need to get Scott Howell involved to demonstrate why we should keep the accounts open. Can you explain to the Commission why Mr. Barton is emailing you about this?
No, you'd have to ask Mr. Barton.
Right. What relevance did this have to your role at Crown Resorts?
The best I can think of is that because I was the General Counsel, the senior lawyer in the group.
And so you'd agree then that this was because that the closure of the riverbank's account was in relation to a risk and compliance issue. And that's why he was emailing you.
I don't know that, no.
But you've said that he was emailing you in your role as General Counsel.
I was guessing that would be the reason why he would be asking me to be involved.
And that's because the closure of the Riverbank investments account by ANZ was a legal and compliance issue.
No, well, I'm not sure about that. I'm sorry. I don't know if that's right.
But you didn't have a financial role at CRL, did you?
No.
Your role as General Counsel was in relation to legal and compliance issues?
Yes, that's true.
And the management of risk?
Amongst other things, yes.
So you'd agree that if he was emailing you in your capacity as General Counsel, that it was because the closure of the ANZ bank accounts was in respect of a legal and compliance issue?
That may have been why he's sending it to me, yes.
Right. If we can go to the source email, please, back to the source email, which is crw.529.008.8581. And you'll see at the bottom, sorry, I'll go back to 8583, which is the second attachment that I took you to, which is the source email for the agenda. The source email for the agenda, please. Oh, I beg your pardon, sorry, I'm getting my documents mixed up. It is crw.529.008.8581, and it's actually the second page. My apologies, operator. Right. And again, Mr. Barton is emailing you an agenda in respect of discussion of these bank accounts because you're the General Counsel of CRL, correct?
I assume so. You'd have to ask Mr. Barton what he was thinking when he sent me the email.
And do you recall... Sorry, okay. And if you go to the first page of this email chain, operator, and you'll see the way that you dealt with it, Mr. Nielsen. At this time, do you recall that Mr. Preston was the General Counsel at Crown Perth?
I believe he was at that time, yes.
Right. And Craig Spence was the CFO at Crown Perth. You've given evidence of that?
That's my recollection.
And you are asking Josh for assistance in dealing with this matter, correct?
That's what the email says, yes.
And you understood it to be a problem?
That's the way I've described it in the email, yes.
And the reason why you're asking Mr. Preston for assistance is because at that time you understood it to be a legal and compliance issue.
I don't remember this email, so I'm speculating as to what I was thinking when I sent the email. I have no recollection of this email other than that I have seen it in the course of dealing with the Bergen inquiry and with your inquiry.
Right. But based on the words that you use in this email, you would agree that you understood it as a legal and compliance issue.
That's a possibility.
And not only that, you understood it to be a legal and compliance problem.
I'm not sure about that. I can't comment.
Right. And in the first email chain, you are sending the email and agendas, and the email with all of its attachments to Ms. Tagoni. Ms. Tagoni was the manager of legal and regulatory services at Crown Melbourne, correct?
Yes.
And
General-
I beg your pardon, sorry, Mr. Nielsen.
No, I would have referred to her as General Counsel, but you're probably right with your title.
Right, so General Counsel, thank you. And Mr. Howe, who was cash transactions and reporting manager at Crown Melbourne at the time.
Yes, I think that's right.
And Mr. Howe was the person who Mr. Barton said would needed to be called in to assist with pitching to ANZ why the accounts should remain open.
I'm not sure that was the words in the email, but yes, he said we would need to get Scott involved.
Right. And here again, you are advising legal and regulatory services, you're advising the General Counsel of Crown Melbourne of this issue because you understood it to be a legal and compliance issue.
I'm not sure that's possible, yes.
In view of this correspondence, I wonder whether you will agree with these propositions. As at 3 March 2014, when you sent these emails on to General Counsel at Crown Perth and Crown Melbourne, you knew that ANZ had concerns about transactions that were occurring in the riverbank accounts?
I don't remember that that's right.
And when you were by referring the matter to you in your capacity as General Counsel, Mr. Barton was treating this issue as a legal and compliance issue?
I don't know whether that's right either.
And that this was a problem that was attended to by risk to the broader CRL group of companies?
I don't know that that's right either.
Right. In respect of the meeting that's referred to in this chain of emails, you may not recall, but it was eventually pushed back to the end of March 2014. Do you have an independent recollection of that meeting?
I have a very vague recollection of the meeting, but I couldn't have told you precisely when it occurred.
Do you recall what was discussed at that meeting?
Not in any detail, only a very vague memory of the discussion of the meeting.
Right. And do you accept that part of what was discussed was why ANZ should keep the riverbank accounts open?
I don't remember that, no.
Do you accept that based on Mr. Barton's email to you that it was likely that was discussed?
I think that was the purpose of the meeting, but so therefore it's possible that was discussed.
So you understood the purpose of the meeting to be Crown putting its case as to why ANZ should keep the riverbank account open?
Again, I have no independent recollection of the lead up to the meeting. I'm interpreting these documents to mean that.
Thank you. If we could please bring up CRL.557, I'm jumping ahead, CRL.557.001.0807_R, please. At the bottom of this email email chain is an email from Mr. Costin on the 29th of April 2014. The recipients are you, Ms. Tagoni, Roland Tyler, Stephen Hancock, Craig Spence, Vasula Kessel, David Brown, and it's copied to Mr. Barton. And the subject is ANZ closure of accounts. Can you see that, Mr. Nielsen?
I can see that, yes.
Right. And it says, following on from our meeting a few weeks back with ANZ regarding the riverbank investment accounts. Mr. Barton and I had a meeting with our relationship manager this afternoon.
Yes, I can see that.
And ANZ have advised they will be closing the riverbank investment accounts. And do you see in the third paragraph, the closure of the riverbank accounts was expected, and these accounts are in the process of being transitioned to CBA. Do you see that?
I can see that, yes.
And the expectation that's referred to in this email is the decision or the flagging of the decision to close the accounts in late February 2014.
I don't know. I assume so. I don't know that.
And that if it had been the purpose of the March 2014 meeting to persuade ANZ to keep the riverbank accounts open, Crown was unable to assuage the concerns of ANZ at that meeting.
If that was the purpose, that would appear to be what this email is saying.
Right. And I just want to ask you about another part of that paragraph where it says, can customers be advised by relevant people that multiple cash deposits in branch under the $10,000 reporting threshold will not be accepted in the new CBA accounts? Do you see that?
I can see that, yes.
And I think your evidence in the Bergen inquiry was to the effect that the responsibility for ensuring that deposits under the $10,000 threshold occurred were the responsibility of the AML compliance department at Crown Perth. Is that correct?
I'm not sure whether that's exactly what I said. I don't think there was an AML compliance department at Crown Perth, but yes, it would have been a Crown Perth legal and compliance responsibility for general AML compliance, including these sorts of transactions.
Right. And when you say these sorts of transactions, what sorts of transactions do you understand them to be?
This is a type of transaction that needs to be looked out for, needs to be monitored in the course of an anti-money laundering program, to my understanding.
Right. And it was your understanding, and you held that understanding in 2014 as well?
Yes.
Right. And sometimes those transactions are referred to as aggregation, as a money laundering typology.
I don't know that I've heard those expressions.
Right. And the second half of that sentence says, we don't want this process to occur again with CBA in 6 months' time, deciding to close the Riverbank and South Bank accounts due to the suspect transactions. Do you see that there, Mr. Nielsen?
I can, yes.
So you accept that the ANZ accounts were closed due to those suspect transactions?
No, I don't know whether that's right. I can see what's in the email. I don't know whether that's right.
What other interpretation is available on those words, Mr. Nielsen?
I don't think that comment is about why the ANZ closed their account.
Right. But Mr. Sorry.
Certainly that's one interpretation that you could take of that phrase.
What's another interpretation?
I'm not sure. I'm sorry, Councillor.
Put it to you that the only interpretation is that the process that Mr. Costin is referring to here is the process of ANZ closing its accounts with Riverbank Investments Proprietary Limited due to suspect transactions.
That's certainly an interpretation that's open.
And then you'll recall that, and it's referred to in this, and then you'll recall that Riverbank Investments Proprietary Limited opened replacement accounts with the Commonwealth Bank of Australia.
I don't. I'm not sure whether that's right. I mean, that would appear to be what's planned here, but I don't recall that.
And in view of what Mr. Costin is saying here about suspect transactions, do you recall if any measures were taken to ensure those suspect transactions did not occur in this Commonwealth Bank account owned by Riverbank Investments Proprietary Limited?
I don't recall whether any specific action was taken. Now, I don't recall this email and I don't recall this line of communication. Crown Perth and Crown Melbourne had anti-money laundering programs there. There would have been processes in place already. I'm not sure whether anything additional occurred this time, but I just don't have a memory of this particular line of communication.
Right. In view of all of that, I wonder if you agree with me when I say the following. The use of the Riverbank account in 2014, the bank account of a wholly owned subsidiary of Crown Resorts, by Crown patrons for suspicious transactions presented a material risk to Crown Resorts.
I'm not sure. I can't comment on that. I'm sorry. I don't know that that's right.
You don't have a view on whether that how about we go with the hypothetical then? If the Riverbank account was being used for suspicious transactions, that then presented a material risk for the parent company, Crown Resorts Limited.
It would depend on the nature of it. I'd need to know a lot more information before I drew any conclusion on that.
So it depended on the nature of the suspicious transaction?
This is all hypothetical, but amongst other things, yes.
And if the account was being used for suspicious transactions, that risk should have been considered at CRL board level?
Again, it would depend. I'd need a lot more information to be able to comment on that.
Right. What about the fact of ANZ raising concerns in 2014 that a bank account of a wholly owned subsidiary of Crown Resorts was being used by Crown's patrons for suspicious transactions? Do you consider that that was a material risk for Crown Resorts?
Well, I don't remember that being raised. And again, I'd need to know more information about that before I drew any conclusion about its material.
Right. Based on the information that we've seen today, do you believe that the concern raised by ANZ should have been considered at Crown Resorts board level?
No, not necessarily. I need, again, to know more information than what we've seen today.
Do you consider that the fact of ANZ deciding to not do business with a wholly owned subsidiary of an ASX-listed company is something that the parent company should have been aware of?
So, well, I'm not sure you correctly characterised what I think's happened or what appears to have happened, but again, not necessarily.
How have I incorrectly characterised it?
Well, I'm not sure that ANZ is saying they don't want to do business with Crown Resort subsidiary. I think what's said here is they're going to close one bank account.
Well, they're closing the accounts of... were you aware of Riverbank Investments Proprietary Limited having more than one account with ANZ?
It may have, I'm not sure.
Right. And not long after this correspondence, there was the first annual meeting of the Risk Management Committee in 2014. If we could bring up and at that meeting, there was an annual review of the risk profile for 2014. If we could go, please bring up CRW.507.006.7406. And you'll see that you're the author of that report, Mr. Nielsen.
Sorry, it's very small on our screen. I'm just waiting for it to get bigger. Just scroll down a bit. Yeah, thank you.
You'd scroll up, please. Yeah, thank you.
Yeah, I can see that now. That's a memo from me to the Risk Management Committee.
Right, and this was one of the documents that you referred to earlier in the examination as that formed part of the Risk Management Committee's assessment of risk.
That would appear to be so, yes.
And have you had an opportunity to look at this report as part of the materials that have been provided to you in advance of this examination?
Sorry, only very briefly. It only came late yesterday.
Can I just scroll down a little bit, please, operator? And you'll see that the only material suggestion in relation to the annual review of risk profile is the addition of a new visitation risk.
Yes, I can see that.
And we can scroll through every page, but I want you to take it from me that there's no mention of the ANZ closure of the accounts in this document. Do you accept that, Mr. Nielsen, or would you like me to take you through?
I'm happy to accept that from you, Councillor.
Thank you. Can I now take you to CRW.507.006.7058_R, please? And this is the report against material risks,
Yes.
which you are the author.
Yes.
And this is the document that we spoke about earlier, which delves more deeply into the risks which are attended to a high level of risk. Is that correct?
It would appear that's what it's going to be, yes.
Right. And again, I'm happy to take you through it, but I would, in view of efficiency, will you accept from me that there is no mention of the closure of the riverbank account by ANZ on the basis of suspicious transactions in this document?
I'm happy to accept that from you, Councillor.
And if we go to CRW.507.011.4884_R, and this is the minutes of the meeting that was held on the 15th of May 2014, of which those committee papers form part of the material presented.
Yes.
And if we scroll through, we'll find again that the closure of the riverbank account by ANZ on the basis of suspicious transactions is not discussed in this meeting. Do you accept that, Mr. Nielsen?
Or it's not referred to in the minutes anyway.
Not referred to in the minutes? But if
it's very hard to read this, but I'll accept it again from you, Councillor.
if it's not referred to in the minutes, then you accept that it wasn't discussed in any material way.
That's most likely right.
Right. And these are the minutes that would have been presented to the Board of Crown Resorts Limited?
Should have been in the normal course, yes.
Right. And if we go to CRL.512.001.5015_R, please, operator. These are the minutes of the meeting of the Board of Directors of Crown Resorts on the 29th of May 2014. And and you are present there as company secretary. Do you see that, Mr. Nielsen?
Yes.
And if you go to page 7, please, operator. And you'll see at the top of the page the minutes of the meeting of the Risk Management Committee held on 15 May 2014 were taken as read, and it was resolved to note those minutes.
Sorry, I'm just reading. Yes, I can see that.
And if Mr. Dixon was to have spoken to those minutes or raised anything, it would have been minuted. You would have minuted it in these minutes.
I should have, yes.
Right. And so the absence of any discussion not minuted probably indicates that there was no further discussion at this meeting.
Probably yes.
Right. So we can see that at a risk management level, the closure of the ANZ bank accounts of riverbank investments was not considered, at least at the meetings that immediately followed that event. Do you agree with that?
That's what the minutes tend to indicate.
Right. And we've heard evidence in this commission that that CRL, directors of the CRL board, including Ms. Coonan, were not aware of riverbank investments until 2019. Can you explain why you decided not to include the closure of the riverbank accounts as part of the material given to the RMC?
No, I have no recollection of that. Sorry.
And can you explain to the Commission why you did not elevate the issue to the CRL board for consideration?
Again, I don't have any memory of those events at the time.
Do you agree that your decision not to raise the issue of the closure of the riverbank accounts at RMC level deprived that committee of the opportunity to assess that risk?
If it wasn't raised at the committee or the board by anybody, then they wouldn't have had the opportunity to assess it. That's right.
And that applies again equally at CRL board level?
Yes, that's right.
And in hindsight, do you consider that this was a failure on your behalf?
No, I don't have enough information to form that view with the wonderful benefit of hindsight.
Do you consider it's a failure of the system that was in place to deal with risks at Crown Resorts?
Not necessarily.
In view of the findings about the use of the riverbank accounts for suspicious transactions in the Bergen inquiry, do you consider that you failed in your role as General Counsel to properly identify the risk that was attended to by the closure of those accounts by ANZ in 2014?
No.
Thank you, Mr. Nielsen. I just want to take you to another topic which we spoke about earlier, which is the VIP business of Crown Resorts. I just need to get some clarity in respect of which entity considered applications for junk operators at Crown Melbourne and Crown Perth.
Junket operators?
Yes.
Yes.
Sorry, could you describe by which how were junket operators approved for Crown Melbourne and Crown Perth during your time as General Counsel?
I'm not sure, I'm sorry. That wasn't a matter that came before me.
Right. It wasn't a matter that came before you during your entire tenure or only prior to October 2016?
it wasn't a matter that came before me in my entire tenure. I'm not sure about prior to 2007 council.
Sorry,
long time.
it is. Sorry, Mr. Nielsen, you misheard me. I've said 2016, so October 2016.
I did hear you, but prior to 2007, when I was General Counsel for Crown Melbourne, in that business, it's possible I knew more about that process then, but I just don't remember it now being so long ago. I'm sorry.
Right. Can we please bring up the document that we looked at earlier today, which is CRL.579.019.5104, which is subject to a non-publication order. In the discussion of customers after October 2016 at these VIP meetings, am I correct in thinking that this discussion involved assigning a risk rating to particular patrons?
I don't remember that. I'm sorry.
Do you recall anything about the nature of the discussions about patrons at these meetings?
I recall that we did look at lists of patrons. At a high level, the focus of those meetings were to determine whether dealing with those patrons was something that would hinder our efforts to have our staff released from detention in China. But as to specifics of individuals and what we discussed about them, I just can't remember. I'm sorry.
Okay. And is it your evidence that you had no involvement with the VIP business prior to October 2016?
When you say no involvement, it's a very broad concept. So I had no involvement in day-to-day business operations of the VIP department, which really was a part of Crown Melbourne and Crown Perth. But issues around VIP would come up in CEO reports and in management meetings, those sorts of things.
And as General Counsel, you had no role to play in assessing whether particular VIP patrons may have presented a particular risk to Crown Resorts?
No, I wasn't involved in that process.
Right. Can we please bring up CRW.709.134.9159, please? And you'll see that this is an email that you've sent to Barry Sargent, the CEO of Racing and Gaming.
I think that this is a document to which an application for an MPO order has been made.
Can you just explain why?
I am so instructed that I think it's just for the private screen presently, Commissioner, but as I understand it, the protocol was that it's been communicated to solicitors assisting the Commission. I'm not presently able to identify the detailed basis for that.
Well, obviously I can only see at this point the front page of the email. we'll leave it off the public screens for the time being, and
I'll see
assess
whether I
the
can
matters
get to
with-
the bottom of it, Commissioner.
thank you, Mr. Damananda. Yes, Ms. Longdrop.
Thank you, Commissioner. If you scroll down, please, operator, you can see that Four Corners have submitted some questions in respect of Crown's VIP business through Crown Resorts.
Yes.
And if you scroll up, please, operator. And you've attached Crown's response and sent it to Mr. Sargent. You see that?
If I can see that, yes.
If we could bring
I
up,
can see it attaches a thing called response to Four Corners.
yes. And if we bring up CRW.709.134.9161, and I'm assuming this should only be displayed on the private screens as well. And that's the attachment to that email.
Used to be, yes.
And do you recall if you were the author of that document?
No, I don't remember.
Do you recall if your team was responsible for creating that document?
No, I don't remember that either.
Would queries of this kind from media outlets be dealt with by the General Counsel team in the ordinary course of events?
Not usually, although we might have been asked to help.
In any event, you agree that you were happy to disseminate this response to the CEO of Racing Gaming Liquor in Western Australia, correct?
I don't have a specific memory of that communication, but it was my habit to keep our gaming regulators informed of media inquiries like this that were likely to result in a media story, to ensure they were informed in advance of such things.
Right, and as a response to a media outlet, as General Counsel, you would have had regard to this before it was disseminated to Four Corners?
Sorry, can you clarify? That was not clear to me, that question.
Sure. In your role as General Counsel, you would have reviewed this document before it was made public?
Generally, that would have been a role that I played, yes.
And let me ask you this, Mr. Nielsen. If you personally had very limited involvement with the VIP and junket business, how were you able to satisfy yourself as to the veracity of these answers?
I'm not sure about this particular document, but in general terms, there would have been a number of people involved in this, including probably people either from Crown Melbourne or from the VIP business, or Crown Perth.
And do you agree that this document was provided to Mr. Sargent as a means by which to give him comfort around the investigation being conducted by Four Corners?
Not sure that's right. It would be more just to alert Mr. Sargent as to what our response was going to be.
Right. And so do you agree with this, that in September 2014, Crown was being investigated by Four Corners as to possible criminal infiltration via junkets?
I all I can remember is there was a story on Four Corners. I don't remember in detail the content of that story and what it covered.
Right, if we could go back to the email, please. Which is crw.709.134.9159. Just want to run you through some of the questions that Four Corners was asking Crown Resorts at this time. What measures does Crown take to eliminate its exposure to infiltration by or association with organised crime? But via its joint venture in Macau, Melco Crown. Do you see that?
See that, yes.
And the second question, what measures does Crown take to eliminate its exposure to infiltration by or association with organised crime via the commercial agreements into which its joint venture in Macau, Melco Crown, enters with VIP gaming promoters, VIP room managers, licensed junket operations and unlicensed junkets and sub-agents? Do you see that?
See that, yes.
And the rest of the questions continue in a similar vein, Mr. Nielsen. So on the basis of receiving these questions from Four Corners, you accept that in 2014, Four Corners was investigating Crown as to the potential criminal infiltration of the criminal infiltration of junkets at Crown Resorts.
I'm not sure whether that's right. It's talking about our investment in Melco Crown. It's talking about what measures we take to eliminate exposure to infiltration as a result of that investment. So I'm sorry, I don't remember these questions other than I can read them on the page. So I'm not quite sure what conclusion to draw about Four Corners investigation.
Okay. But you'd accept, though, that Four Corners is asking Crown Resorts questions as to the potential for criminal infiltration by... Sorry, the potential for criminal infiltration by organised crimes into its junket operations.
Via its joint venture in Macau, yes.
Right. And if junkets at Crown Resorts were being infiltrated by criminals, that would present a significant risk to Crown Resorts, would it not?
I would think that would be a risk for Crown Resorts, yes.
Right. And the potential for that risk to occur, but risks do not have had to have materialised in order for them to become a risk. You also account for potential risks in your role as General Counsel, correct?
I think that's a general principle of risk management, yes.
Thank you. And if we can bring up CRW.507.011.5681, which is the next lot of minutes from the Risk Management Committee in 2014. This is the minutes of the Risk Management Committee on 25 November 2014. And we can scroll through them slowly, but you can also take it from me that there's no consideration of the criminal infiltration of junket operations at Crown Resorts in these minutes.
I'll accept that from the council.
Thank you. Do you accept then that there's no consideration of the risk of criminal infiltration directly following, at Risk Management Committee level, directly following the Four Corners investigation?
I accept there's no minute of any discussion.
And therefore, by extension, do you agree that there's no consideration by the CRL board in relation to criminal infiltration and what risk it might present to the company?
Not by these minutes, no.
Do you recall? Sorry. Do you recall why you decided to not raise this as a potential risk at the Risk Management Committee in November 2014?
No, I don't have a recollection of that.
Thank you. I just want to fast forward to 2016. This is subject to a non-publication order. It's CRW.710.004.8085. And if we can please go to the start of this email chain. This is an email from Ms. Tagoni to Mr. Preston, and it's carbon copied to you. And this is January 28, 2016, so prior to the China arrests. And Ms. Tagoni says, these are the named individuals to whom the media requests relate. And you'll see one of them is Mr. Richard Young.
Yes, I can see that.
Do you have any recollection of this patron?
No, I'm sorry.
Right. Do you recall anything about this media request?
No.
Do you accept that these patrons are being investigated by media outlets as at 28 January 2016?
No. I don't accept that because I'm not sure that's what the email says.
Right. Or at least that media are making requests about particular patrons, about these particular patrons.
It would appear they're making requests about those patrons, according to Dan in the email.
Thank you. And if we can please bring up CRW.710.004.8645. Is this a non-publication? Also subject to non-publication order. This is a week later, 5 February 2016. And this is an email from Ms. Fielding directed to you and carbon copied to Ms. Tagoni and Mr. O'Connor. Do you see that, Mr. Nielsen?
It's very small, but I think I can see it.
And the subject line is Yong and Fua. And you'll see that there's some discussion about those two patrons in the body of this email.
It's just been made bigger for me, thank you. So, you want me to read that?
Yes, please. So Ms. Fielding is requesting for your input, your comments, before she sends it to Howard, Mr. Michael B, Andrew Spry and Kevin. Do you see that?
See that up the top, yes.
Right. So is this, as lawyers, we all understand that documents may be settled by our seniors before being disseminated more widely. Is this the process that's going on here?
I'm really not sure. I don't remember this email. I don't remember these patrons, I'm sorry. When I know Ms. Fielding and her role, I'm just still halfway through reading it. But,
Sure.
yes, I'm not sure. I'm sorry, Council, I'm not sure.
do you recall that you made the decision that Mr. Yong was not able to attend Crown Melbourne?
I don't remember that, I'm sorry.
But if it had been you, this would be an example of your involvement in the VIP business.
That's what happened. That might be an example of that, yes.
Right. And if we go to CRW.710.004.8111, this is a non-publication order document as well, please. And this is the final, Ms. Fielding is forwarding you the final version of the email with the subject line Yong and Foie to say that she spoke with Kevin before sending it and that he was aware it was coming.
Yes.
And then the body of the email is, in essence, the same as the one I just showed you. Do you accept that if Mr. Yong, in this email, it's preventing Mr. Yong from gambling or soliciting anyone to gamble on his behalf at Crown Melbourne?
On my quick read of it, that's what it looks to be.
And this patron pose a significant enough risk to ban him from doing those things?
Apparently that looks to be what the email's talking about.
And do you agree that it carried with it the decision to ban Mr. Yong carried with it a reputational risk to Crown Resorts?
Not sure whether that's right or not.
Right. He was the subject of a media request at the end of January 2016, correct?
Yes.
And
so there was a publicity risk of some kind.
Right. Thank you. Can we bring up the minutes of CRW.507.011.4624? And these are the minutes of the RMC meeting that occurred, the next RMC meeting that occurred after this, banning of Mr. Yong, on 22 June 2016. Do you see that, Mr. Nielsen?
Yes, I can see that.
And if we could scroll through to reputational risk, if there was any consideration of that in these minutes. And you'll see, if we go back one page, please, to page 2, under the heading Brand Reputation Image, you'll see there's no mention of Mr. Yong being banned from Crown Melbourne there.
You make it bigger for me, Council. I'm sorry, it's very hard to see.
Certainly. Sorry, Mr. Nielsen. Thank you.
There it is. No, there's no mention there, you're right.
Right. And can you take it from me as well that there's no independent mention of Mr. Yong's banning in these minutes, please, Mr. Nielsen?
Except that, yes.
Can you explain to the Commission why this matter was not brought to the attention of the RMC?
I don't have any independent recollection of that particular meeting or the minutes that are in front of me. But as a matter that Crown Melbourne was dealing with, I would have thought if it was going to be brought up as a material issue, it would have been raised in Crown Melbourne's risk process.
Right, but earlier on in the examination, you accepted that Crown Resorts Limited takes ultimate responsibility for the risks of the group. Should it not then have also been considered at Crown Resorts Limited board level?
If it had been considered material enough, having come through the risk management process that we've discussed earlier, yes, that's right.
And in respect of the criminal infiltration of junkets and the VIP market. In general, how did Crown Resorts deal with that risk during your time as General Counsel?
Through the process that we've talked about at length earlier in this hearing.
Right. And do you agree that the failure to bring these matters, to bring matters such as this, of the banning of Mr. Yong, for example, to the CRL board's attention diminished its ability to properly oversee the risk of criminal infiltration at its properties?
No, not necessarily.
How was it able to otherwise do it if it wasn't being brought to its attention?
Well, as I've outlined previously, we've discussed previously, there was a process by which the business determined and assessed the materiality of risk. Based on that process, the risks which were considered high or significant were brought to the attention of the committee in the manner which we've already talked about.
Right. And in respect of the October 2016 arrests and the decision to then convene a VIP meeting, which you discussed earlier,
Yes.
did the change in process indicate that the reliance on the properties to deal with criminal infiltration prior to that was not working?
No.
Thank you, Mr. Nielsen. I just have a few more questions in respect to board charters. You're aware that the Burswood Limited Board does not have a charter?
That's probably right. I mean, my memory is imperfect on that, but I don't recall it having a charter.
And I've shown you the CRL board charter earlier today and the RMC charter. Who was the author of those documents?
I'm not 100% sure, but my guess would be that Mary Manos prepared those after the demerger.
And to your mind, is a corporate charter of a board an important document underpinning governance?
Yes.
And you then can you explain then why Burswood Limited does not have a charter? Or
I can only suggest that as a wholly owned subsidiary, it would be rare in my experience for wholly owned subsidiaries to have charters.
do you agree that the existence of a board charter might have helped with the demarcation of responsibilities, particularly as to risk between Burswood Limited and CRL?
Maybe.
And do you accept that it was in your power as company secretary to recommend to Burswood Limited that it had a board charter?
I could have done that, yes.
Thank you, Mr. Nielsen. No further questions.
Thank you, Ms. Longdroppett. Now, Mr. Bathurst, any questions?
No, Commissioner, thank you.
Mr. Evans?
Could I just ask one quickly, Commissioner? Mr. Nielsen, my name's Evans. I act for the Gaming and Wagering Commission. Can I just clarify one aspect of your evidence? I could probably wait for the transcript, but I'm impatient. My learned friend took you to the Four Corners email to Mr. Sargent. You recall that?
Yes, I do.
Am I correct in understanding that your evidence was that you thought that the Four Corners investigation was concerned with the Melco joint venture in Macau?
I was just, sorry, Mr.
And not with Crown's Australian operations?
No, I was just commenting on the particular questions that Council took me to in that email. I don't have an independent recollection of the particular item of the Four Corners piece that was done, but I had read the questions and that was my interpretation of those questions.
Can I take you back to that document, CRW.709.134.9159?
Yes.
And can I take you to the third and fourth bullet points on that page?
You want me to read those, Mr. Evans?
Could you read them? Yes. They might need to be enlarged for you to facilitate that.
No, it's been enlarged. I can see that. Thank you. Yes, I've read those.
I draw your particular attention to the reference to investigations into its junket operators in Australia.
Yes.
Now, that's a question squarely posed about Australia, isn't it?
Yes, it is.
And if I roll the page down to page 9160, can you read the first bullet point?
Yes.
That's arguably a question about Australia, is it not?
Yes, it is.
And could we go to the response which you apparently attached, which is CRW.709.134.9161?
Sorry, the blank. Yeah, now it's been made bigger.
Now,
Yes.
as an initial question, can you indicate who within the Crown organisation would have had the authority to and did in fact authorise the making of this release?
I can't tell you who did in fact because I don't remember this particular document, but generally the CEO would have authorised that.
And at the time that would be Mr. Barton, is that correct?
Mr. Craig.
Sorry, Mr. Craig, my apologies. That's
Mr.
right.
Craigie.
Craigie, that's right. Yes, thank you. And can I just take you down to the bottom of that page under the heading Junket Operators and ask you to read the first and third paragraphs.
Sorry, did you say the first and third?
First and third, yes.
Yes, I've read that.
Now, it's clear from that, isn't it, that whoever penned this and authorised its release understood that the question was posed in relation to the Australian operations
Yes, it would appear so.
and answered in relation to the Australian operations.
Yes, that's right.
Yes, thank you. No further questions, Commissioner.
Yes, Ms Young.
Commissioner, with your leave, just a matter of clarification.
Yes.
Mr Nielsen, can you hear me?
Okay.
My name is Young and I appear for CPH Crown Holdings and Consolidated Press Holdings. Can I please have the operator pull up, and I understand this has an NPO, CRL.579.019.5104.
Yes.
You recall in your evidence you were taken to this, and so I understand your evidence, you described this as an example of a meeting which occurred only after the China arrest in October 2016, correct?
Yes, I think that's right.
And to your recollection, Mr James Packer first ceased as a director of Crown Resorts in December 2015?
To the best of my memory, I think that's right.
And he was not appointed as a director again until August 2017?
I think my memory is that he was announced to become a director earlier than that, but there was a period of time that he had to go through approval for gaming licensing purposes. So I think people knew earlier than that he was going to become a director, but I think he only actually became a director later.
Yes.
as you say, August, although I was not in my role any longer at that time.
Yes. If I could ask the operator to pull up, please, pub.0013.0001.1261. Mr Nielsen, do you see that there? It's the annual report of Crown Resorts from 2017.
Yes.
If I could ask the operator, please, to go first to PDF 75, which is page 1335. And if I could ask, please, for the operator to scroll down to the table headed 30 June 2016, Crown Directors. And just to blow up that table there, please. Ms Nielsen, can you see the note that's at the bottom of that table that commences Mr Packer ceased as a director on 21 December 2015?
See that? Yes.
And if I could ask, please, the operator to turn back to PDF 39, which is page 1299. And go down the left-hand column, it's the third bullet point from the bottom.
Yes.
Sorry, operator, under the heading Significant Events After Balance Date. That first dot point there, can you see that, Mr Nielsen?
Yes, I've seen that.
On 3 August 2017, Crown announced the appointment of Mr Packer had become effective.
I can see that, yes.
And that's the later date you were referring to in your answer to the Commission just now.
That seems to be right, yes.
Yes. The Commission, please.
Thank you. Mr Damananda.
Yeah, no, thank you, Commissioner. No
Thank you.
questions.
Mr Nielsen, that just leaves me. Just wanted to clarify a few things with you. In your evidence, you said that you didn't have enough information to assess whether it was a failure by yourself not to raise the ANZ's concerns, which led to the closure of the riverbank account at the RMC or at the CRL board level. Just wanted to know what further information would you need in order to make that determination?
I would need to know more detail about the reasoning behind ANZ's closure and the facts and circumstances around that.
So given what you were told in at least or by April 2014 about that issue, should you have made inquiries in order to find out whether ANZ's concerns did identify a potential risk that should be reported to the RMC, Crown Resorts Limited or Burswood Limited?
I'm not sure, Commissioner. As I said to Council, I don't remember those events or those communications. I do have a vague memory of that meeting with the ANZ, but I don't remember what I was advised after the meeting and what occurred at that point. I've seen the emails, but I don't have a recollection.
Is there any particular reason why you don't have a recollection, Mr Nielsen?
7.5 years ago, Commissioner.
How many meetings did you go to with banks about closures of accounts?
Well, not many, but I went to a lot of meetings and had a lot of emails and a lot of correspondence and involved in a lot of projects.
Would you agree with me, though, that it would be a fairly rare occasion where a bank said that it wanted to close an account used by Crown because of suspicious transactions on it?
Well, I don't remember that that's what they said, that it was because of suspicious transactions on it. I would agree with you that it's not a common occurrence for a bank to close an account.
You don't agree with me that at least by the 29th of April, when you were received that email, which referred, and you were shown it where it's highlighted in red, that can customers be advised by relevant people that multiple cash deposits in branch under the $10,000 reporting threshold will not be accepted in the new CBA accounts, as we don't want this process to occur again with CBA in 6 months' time, deciding to close the Riverbank and South Bank accounts due to the suspect transactions. Are you suggesting that by that time, being the 29th of April 2014, you did not know that ANZ wanted to close the Riverside, or had closed the Riverbank account because of suspect transactions of that nature?
Yeah, I don't recall that, but that is an interpretation of that document. I would consider that.
What other interpretation could you have come to?
Well, it would depend on what I knew about the reasons for the ANZ closing the account, which I don't have a recollection of. I'm sorry.
And my understanding is that neither can you account for why you didn't make inquiries as to why the ANZ Bank was closing the account.
No, I don't remember the circumstances at all, Commissioner. I'm sorry.
Can I ask you about a related matter? At the RMC meeting on the 15th of May 2014, there was yourself, there was Deborah Taccone, there was Craig Spence, and there was Joshua Preston, all present. Do you agree that all of those people were aware of what had occurred in respect of the Riverbank account and ANZ?
The emails, that would appear to be right, yes.
Would it not make sense then for someone, one of those people, to, at a risk management committee meeting, to have said, oh, why aren't we discussing the risk that's been raised by ANZ and suspect transactions on the Riverbank account?
Yes, it may have. I can't account for why that wasn't done.
Was there any discussion beforehand to the effect that it was not going to be raised?
Not that I can remember.
Could we then have a look, please, at CRW.709.134.9161? These are the answers to the Four Corners inquiries. And the last page, please. And the bottom of the last page, which refers to the AML answers. Could they just be pulled out and Mr. Nielsen be given the opportunity to read those?
Yes, Commissioner, I've read that.
Now, you saw these answers at the time, didn't you, in September 2014? That's been established by the email chain?
Yes.
This was 5 months after ANZ had closed the Riverbank account because of suspect transactions of multiple deposits under the $10,000 threshold limit. Reading that response, why did you think that that was a full and frank response to the questions asked by Four Corners?
I don't remember the response or the preparation of the response, so I can't tell you what my state of mind was at the time, Commissioner. I'm sorry.
So you're also telling us that you can't recall whether it occurred to you, oh, that seems a bit odd in respect of having regard to what happened 5 months ago in the ANZ riverbank account?
I can't recall that. I'm sorry, Commissioner.
In respect of the meeting in March 2014 with ANZ, can you just exhaust your memory, please, as to who was present at that meeting? For Crown, not for ANZ, for Crown.
Mr. Barton, to my memory, was there, and Mr. Goni was there. I think Mr. Preston was there, but he would have had to have been on the phone. I'm not sure about others from Crown and whether they were there. That's possible, but I don't remember.
And can you exhaust your memory, please, as to what was said by ANZ about the closure of the riverbank account?
Look, I only have a very vague memory of the actual discussion at the meeting. The one memory I do have is there was discussion around how funds were transferred from overseas into Australia, insofar as how it was recorded, if you like, and how it was reported. But other than that, I don't have a memory of any specific transactions being discussed.
Do you recall what the issue was in respect of the recording of overseas transactions into the account?
My only vague memory, Commissioner, is that it had to do with the operation of the international funds transfer requests that were required to be reported to Austrac, and the interplay between the bank's obligations and our obligations. But I don't remember the specifics, I'm sorry.
Then moving to the final topic, in relation to your AML training at Crown, can you tell me what it was?
Do you mean, can I tell what its content was?
No, really, basically what courses you did, if any.
My vague memory is that there was a component done at induction when new employees started. But I have a memory that there were sessions for existing employees as well. Crown Melbourne, which I'm probably more familiar with than Crown Perth, had a training college where employees could go for training. They had
I'm not, sorry, Mr. Nielsen, I'll stop you because I think you might have misunderstood my question. My question is, what was your training? Did you do any of those courses, and if so, when?
I don't remember doing any anti-money laundering courses, no.
Thank you, Mr. Nielsen. I don't have any other questions of you. Ms. Longdropper, anything arising from that?
Nothing, Commissioner. Thank you.
Mr. Rubenstein.
It's 1 moment, please. I'll just get some instructions from my instructor.
Certainly.
Commissioner, no re-examination.
Thank you, Mr. Rubenstein. Mr. Nielsen, thank you very much for your attendance where you are today. Your evidence has now concluded for the afternoon. We will leave the summons in place just in case there are some further questions, but certainly for the time being, you're free to go about your business. Thank you very much. The link will now be turned off. We will adjourn until 2 p.m.
All rise.